Good morning, sir. You are Lotharia Jacob.
Yes, ma'am.
And Mr. Jacob, you were previously in court, entered a plea of true to count 2, and a motion to revoke your probation. Looks like you're on probation for the 3rd-degree felony offense of driving while intoxicated, 3rd or more. And let me get that pulled up so that we can go through. Does the state have evidence with regard to any of the other counts?
Yes, Your Honor. Probation officer here can testify as to count
Give me.
count 1.
Okay. Mr. Nichols, with regard to count 1, you may call your first witness.
Thank you, Your Honor. The state calls Cimaria Jefferson.
Good morning, Ms. Jefferson. If you'll please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Ms. Jefferson, are you the probation officer assigned to monitor Lotharia Jacob?
Yes,
And how long have you been assigned to this case?
since about September when he was continued on probation.
Okay. And as part of his conditions, is he ordered to remain in Jefferson County
Yes,
with an exception for employment, correct?
yes,
And so during your period of supervision of Mr. Jacob, did the GPS monitor indicate he was in Galveston County, specifically in Gilchrist and Galveston, the city of Galveston?
yes,
Did you ask him about that and try to ascertain if he was there for work purposes?
yes, I did.
And what did he tell you?
He actually denied going to Galveston and Gilchrist.
When was this conversation?
It was during an office visit on November 20th.
November 20th.
Mhm.
And after that conversation, did he bring you any documentation showing that he was in Galveston County for work purposes?
No, he did not.
Thank you. I'll pass the list.
Any other witnesses?
No, Your Honor.
Okay. Any witnesses with regard to count 1 then, Mr. Rojas?
Just Mr. Jacob, briefly.
Mr. Jacob, the best you can, raise your right hand, please, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I did.
All right. Thank you, Mr. Rojas.
Okay, Mr. Jacob, you heard Ms. Jefferson's testimony, right?
Yes.
And you recall the day she was talking about when the GPS showed that you were in Galveston?
Yes.
Okay. So, first off, is it true that you denied to her that you were there?
No, I did not. I told her I was going out there. I worked out of town a lot.
Okay,
And I said I was out there in the morning.
okay. So, could it maybe just been a miscommunication between the two of you?
That's the only time I was. I used to go to work.
And so, are you telling the court that the days that the GPS showed you in Galveston and Gilchrist, you were actively working?
Yes.
What kind of work do you do?
I do concrete work.
And the concrete work that you takes you to various locations
Correct.
around
Around.
Southeast Texas.
Correct.
And are you telling the court that you did not intend to mislead Ms. Jefferson when she asked you about where you were out of time working?
No, I wasn't intending on this.
Okay, you think it might have just been a miscommunication?
Who had been there, if she was questioning that you were, don't talk over me, let me finish my question. So if you disagreed and with her that you were there for work and not for something else, then why didn't you do anything to give her some information, or your attorney at this point some information?
My attorney did. I talked to my boss man.
Mm-hmm.
And he had,
With courtroom, I did speak with Supervisor Mike, I think it is his last name, Judge, but he says that it's true, they do work out of town, they go various locations all over Southeast Texas. He didn't have any documentation as to what date they were working out of town in Gilchrist. He couldn't confirm or deny whether it was this date or not, but he did say they do work sometimes out at the beach or Galveston. He just couldn't tell me whether these dates were those dates they were there or not.
Okay. We're out of the county without permission. And so you had permission to work, but when something comes up, I would think that there was an issue with regard to whether or not you were working on that day, and you didn't provide any verification of that, then it really doesn't leave me much choice at this time other than to find count 1 true. So I am at this time, based on the testimony, going to find count 1 true. Again, there was a plea to count 2 of true. I've received the updated as well, and you pled true to that. So, Mr. Rojas, you may proceed.
Judge, as to that allegation number 2, speaking with Mr. Jacob and again with his supervisor, what Mr. Jacob tells me is that he blew into the breathalyzer. He blew into the blade, so that sometimes his job takes him to different locations where he'd have to park in a parking lot or on the street somewhere, and they walk to the job site, which can be, quite a distance away. And by the time he'd walk from the job site back to his car, the time to blow into the machine had passed, and that's why they're coming up to failures. There's no excuse for being late, Judge. He should have known when he should have been there, made plans. But it's not like he was blatantly not blowing into the machine. According to him, he was doing it. He was just doing it late, and it's because he was at work and the job sites were quite a while away from where the machine was parked in his car. What Mr. Jacob is asking the court to do this morning, Judge, and I know it's hard to ask this from the court. He's asking the court to reinstate him. He's already been to the JCDI more than once, I believe. I don't think we've got any positive or positive tests for alcohol. It's just the timing on getting it done. I've spoken with him on several occasions about how important it is for him to take these tests whenever the court tells him. It's not up to him. The court tells him when to do it, and that's when he's got to do it. I think he understands it now.
But Mr. Jacob, you can't just keep messing up and then say, okay, I get it this time. Just let me out. I'm going to do it. You were here. Okay.
Judge, and I don't think Mr. Ross intentionally misstated, but because it's not on the report, but in the admin hearing, there is a positive alcohol test mentioned from early November. I know he may not have that in front of him. Just want to clear that up. But that it was a low blood alcohol at 8 o'clock in the morning, November 2nd, 2024.
Yeah. I see that. It's 0.003.
At 8 in the morning.
At 8 in the morning, so. And then missed subsequent test that day. I mean, okay, I want to make sure that I have this right. So it looks like you went to the Unity house for 30 days. Within 2 months of the release from there, and this was at the beginning of your probation, let me go through. Began JCDI program April of 2022, shortly after you got on probation. And since, therefore, you were ordered to complete both tracks of ISF, which it looks like you did, completed December 28th of 2023. Then you go back to JCDI for aftercare, again struggled to comply, testing positive, forging your required meetings, and operating a motor vehicle without an interlock. This led to unsuccessful discharge from JCDI and a motion to revoke. And so you came here on a hearing on a motion to revoke. I left you on probation, continued you, ordered you to re-enter the JCDI program. You were going to be on the high-medium caseload, continue with your portable monitoring device, and it was going to be 0 tolerance. Then we're here again with failing to comply with that portable device at least, it looks like 19 times. You didn't do that. And then we've got the issue with you being in Galveston and Gilchrist without permission. So it looks to me like you've tried and started but never finished JCDI. Is it 3 times, I believe? But I'm supposed to just go, and you've been to ISF, and you've been to the Unity House. I mean, when I'm saying that out loud, think about how it sounds for you to go, well, just let me out this time. I got it. I got it. I'm going to do good this time. You see what I have to worry about? I have to worry about everybody being safe.
This is the most dangerous phase for any defendant. Pattern recognition. Treatment programs, second chances, third chances. Once the judge starts listing them out loud, it's no longer about a single violation. It's about whether the system believes you can be supervised at all.
Mr. Nichols?
I'd urged a 5-year cap in September, Your Honor. There was no agreement on sentencing in this case for today. But I just feel that zero tolerance needs to be zero tolerance, because after that, it only took a couple of weeks for him to start violating.
So, Mr. Jacob, I'm going to find that you entered your plea of true to count 1 freely and voluntarily. Find that count true. I've already found count 2 true based on, no, the opposite. You pled true to count.
4 years isn't just a punishment, it's a conclusion. The court has decided rehabilitation under supervision has failed. This isn't about anger or revenge. It's about public safety and limits. So, here's the real question for you watching. How many chances should the system give before accountability becomes
I found
confinement?
count 1 true today. I'm going to find sufficient evidence to revoke your probation, and at this time, revoke your probation. I'm going to reassess your punishment at 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification. I need you to sign this, and I'll give you a copy. It shows this was not an agreement, so you do have some rights to appeal. You can talk to Mr. Rojas about that. Good luck, sir. Thank you, ma'am. You'll just email the attachments to the clerk. Good morning. You're Ray No?
Good morning, ma'am. Yes, ma'am.
And will your client waive the formal reading of the indictment in each case?
He does, Your Honor.
Just a second. Figure out what today is. Sorry, can you get in there? Mr. No, in cause number 25, DCCR 0386, you're charged with the second-degree felony offense of intoxication manslaughter with a vehicle from December 11th of 2024. And how do you plead to that charge?
Guilty.
And y'all have marked here aggravated. What is,
Defense counsel put that here.
Yeah, well, they charged it as aggravated with a vehicle, I believe. It was aggravating.
It's just a garden variety intox.
yeah, I'm going to mark that out because I think that might
Feel free,
have
Judge.
some
Different context.
context at sentencing that you may not want. All right, so it's, how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
Sorry, give me just a second to get to the other one. And then in cause number 25, DCCR 0387, you're charged with the state jail felony offense of driving while intoxicated with a child passenger from December 11th of 2024. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you did what they've charged you with?
Yes, Your Honor.
In each of those cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Franklin?
Yes, Your Honor.
Do you fully understand them?
Yes, Your Honor.
And do you understand that it's first of all, it's the way this is written up is that you are pleading open to the court. There's no agreement. Is that correct?
Yes, Your Honor.
And so you guys, a couple things. I need the other one sent back. So is it on the trial court certification of defendant's right to appeal? On this case, the state jail, the admonishments were signed saying that they're waiving the right to appeal. And then on the certification, it's actually 2 of them were checked off. One is the defendant has waived the right of appeal, and the other is it's not a plea agreement and the defendant has a right to appeal.
It's not a plea
It-
agreement,
Right.
so that's correct.
Okay, so with everyone's permission, then I'm going to erase the check mark on the defendant has waived the right of appeal because it's not a plea, so he will have some right to appeal.
Yes, Your Honor.
No objection.
Also, on each of the paperworks on the post-conviction waivers that you both signed, I will mark that out as well because that's saying that he's waiving his right to appeal.
Yes, Your Honor.
No
Okay,
objection.
all right, thanks. So,
Your Honor, I would note too, I think I had a few stray, I'm a left-hander. I think there's a few other stray marks on there that
Okay.
I tried to erase and wasn't able to.
Gotcha.
So if you see those, I apologize.
gotcha.
But my hand
We
taps.
understand the left-handed issues up here. Ms. Werner feels your pain on that. Okay, so I want to make sure you understand a couple of things. You have an absolute right to have a jury come in and determine two things in these cases. The first would be to determine if you're guilty or not. And then the second would be if they find you guilty, you could leave your punishment up to that jury. If we go forward this way, you're waiving that right and you're leaving your punishment up to me in each of these cases. And is that what you want to do?
Yes, Your Honor.
All right, state tenders number one in each case.
No objection, Your Honor.
It's admitted. Also, sir, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, Your Honor.
All right. Is there any evidence that Mr. No is not competent?
No, Your Honor.
All right, sir, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of those pleas, find sufficient evidence to find you guilty. However, I'm going to reset your cases for a sentencing hearing so that the probation department can do a pre-sentence report. That'll give me more information about you, your cases, and then we'll come back later for sentencing. Obviously, if there's anything important that you want me to know, get that information to Mr. Franklin. He will present it to me on your behalf when we come back. Do you guys anticipate a little bit of extra time on this one as far as witnesses or argument,
Just brief, not much.
but a little more than normal?
Yes, Your Honor.
Okay, so if I were to set it at 11 on a docket date, we could, maybe an hour would be enough? Or do you
Yes,
think
Your
we
Honor.
need
I think
some?
an hour.
Okay, all right, so we'll reset it for sentencing and we'll just do it at the end of a docket so you don't have to sit and wait unless you have some other cases. You need to stop and talk to probation on your way out of the courtroom and she's sitting at that desk right over there. All right, we'll see y'all back at sentencing. Thank you.
Thank you, Judge.